Necessarily those of this station, its staff, management, or sponsors. Welcome to the Ask the Experts Show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
And I'm Rhonda with Ask the Experts, filling in from Steve-O while he's out on surgical leave. Tonight it is the first Wednesday of the month, and I'm joined by Robert Kaye, who is our guru in community association law. How are you doing tonight, Robert?
I'm doing well. How are you, Rhonda?
I'm doing well. So why don't you remind folks why it's important to have a lawyer when it comes to community management and what you do?
Well, what we do is provide full legal services to community associations throughout South Florida on our 3 offices in Pompano Beach, Palm Beach Gardens, and Tampa. On all aspects of the day-to-day operation, as well as any additional issues that may come up for litigation or contract negotiation or contract dispute, construction defect litigation, collection of assessments, addressing covenant issues within the community. All of the things that associations will face on a day-to-day basis, and we've been doing so continuously since 1991. And hope to continue to do so well into the future.
Your show is always very popular. I mean, we get a lot of listeners who write in, we get a lot of calls, and I want to remind folks that if they do have a question for you, the call-in number is 1-888-565-1470. You also hear that your classes are really good. You guys offer a number of classes.
We do. We have been giving them, of course, in our office and out and about the community, but with the current situation and the lockdowns, we've gone to a more remote setting. We have some classes coming up in the next couple of weeks. On Wednesday, July the 8th at 10 a.m. to 11:30, there is the 2020 legal update. It's a 1-hour presentation, although it's scheduled for an hour and a half. That covers the changes in the laws that were adopted in 2019. They call that the 2020 legal update. Those are going from October through September each year. So until September, we'll still be doing the 2019. Peter Mullengarden will be teaching that class online and available through our website at kbrlegal.com. On Thursday, July the 9th at 1 o'clock till 3:15, Andrew Black will be teaching a condominium association board certification class, which is a requirement for board members and committee to be certified so they can continue to serve on their boards. And then on Thursday, July 23rd at 1 o'clock, we have a popular one called Navigating the Federal Fair Housing Act, Assistance, Animal, or Pet. That will also be taught by Andrew Black. And you can go to our website at kbrlegal.com to register for any of these upcoming classes and check for future classes that are going to be scheduled as well.
So a lot of good information out there.
Oh, yes. And we continue to add different things all the time.
So I'm going to start with some of the questions that we got from our listeners. John writes, I own a condo in Broward, and our board is starting to hide information from us, and now they are doing closed meetings. How can we keep tabs on them?
Well, if the board is not acting in the open as they're supposed to, and you're a condominium, which is helpful, you can contact the Division of Condominiums in the Fort Lauderdale office. You can go to the Department of Business and Professional Regulation website and go to the Division of Condominiums to find information more specific to how to contact. But you can indicate that the board is violating Florida law and failing to post notice of their meetings, having meetings closed to the unit owners, failing to provide information. You can do a record inspection request, which should be in written form. Submit that to the association, and the association would have to provide you access to the official records of the association within 10 business days, or else there's potential issues with respect to that. And the division will enforce on that as well. If none of those are satisfactory, you may have to bring in your own personal attorney to get things right within your association. The other alternative you have is politically. You can, if you have enough other interested unit owners, remove those in the board who are not doing the proper job through a recall. You can do that by a written agreement, which is in essence a form that's available on the Division of Condominium website, and you just need to get more than a majority of the owners to be signing on these agreement forms and then deliver them to the association in the way that the directions are spelled out right on the form. And then the board would be removed and replaced if you're doing a majority of the board, or the board would replace whatever individuals that you replace if it's less than a majority. The last alternative politically is at the upcoming annual election, whenever that may be, to put in board members who are going to operate it the way that is best for your community.
Is the board required to give full disclosure of accounting records, how much money they spend to replace the roof, et cetera?
Yes, that's part of the official records that the statute identifies as being fully available to the unit owners at any reasonable business hours upon written request for the access. Now, a lot of unit owners make a mistake and they'll send a letter or an email to the board or management, say, send me copies of this, send me copies of that. That would not be a proper request under the statute. You have to ask to have access to and inspect the records, and then do that inspection yourself, or have a representative go in and do the inspection, identify the documents you want copied, or if you bring a phone or a copying device, you should be able to make your own copies on the spot. And if the board does not allow you to do that, then they're in violation of the statutes, and the Division of Condominium will enforce that on them.
Yeah, I think, you definitely should know how your money's being spent. It's helpful, right? I want to remind our listeners, if you do have a question for Robert Kaye, an expert on community association law, the phone number is 1-888-565-1470. We're going to go to our next question. Our listener writes, can you use a person's prior criminal record for moving into the community?
Well, first off, you have to have the authority in your governing documents to approve either tenants, guests, or owners based upon certain criteria. Among the criteria that is often looked upon is criminal background.
I'm sorry to interject here, but we actually now have 3 callers, and I don't want to lose them. So can we come back to answer that question after we take these callers?
Absolutely.
Thank you. Okay, caller, you're on.
Hi. Can you hear me?
We
Yes.
can.
Okay, great. Okay, so our station is a homeowners association and been here for 19 years. Since then, road that leads into our community, they have built a police station, a community center, a grade school, and a church. And there are also city events that block off our street that we can't get out. So right now they're in the process asking to make the church bigger. And I'm wondering, they're telling us that we own the hills of the road. So we have to cut the grass, we have to clean it, but city owns the road, and that's why they can have all this. and there's only one lane in and one lane out. So there's school traffic. We can't get out of our own complex.
Hmm.
Is there
Well, that
anything
sounds difficult. What is your question with this?
is there anything that could be done, being that there's only one way in and out of our community, and put all these other things on there? They said because the road is actually city, even though maintain the sides of the road.
Well, this is something, and I'm sorry, we didn't get your name. What was your name?
Erna.
Erna? Erna, this is an issue that's, I think, going to be specific to your documents in order to see if there's any possible assistance. It sounds as if, as time progressed from when your community was first developed, there was no prior plan to protect you from the things that have occurred. And depending on what's in the surrounding areas will dictate whether you have many options in what you can do to try and make things better for your community under the circumstances.
But the
So
docks
I
are
think
only
that,
related to the inside. This is outside the community.
well, they're related to everything that is subject to the documentary requirements, which you've indicated is the along the roadway. You have certain maintenance responsibilities that's going to be set forth in there as well.
Right, but not
Have
the
you?
road. They're saying the road belongs to the city. Is there any recourse for us?
Well, your issue is way more complicated than a call-in radio show can assist you with. And I'm afraid
Okay.
I'm going to have to suggest that you need to consult with an attorney that's versed in planning issues on a citywide level to assist you in possibly finding remedies to the situation that the community has found itself in over the years.
Okay, well, thank you.
All right, well, thanks for listening.
Thanks for your call, Erna. We have another caller on the line. Caller, what's your name and what's your question? Let's see if we're connected to the next caller. I don't know if you can hear me, but next caller, what's your name and what's your question?
Hi, I'm Bonnie. Yes.
Hi, Bonnie.
Hello, Bonnie.
Hi, I have a question about ACC compliance. For 20 years, our homeowners association has approved flat or barrel concrete tile clay roofs, and the color palette's been modified several times to add additional colors. But the ACC committee has never approved wood, asphalt, metal, vinyl, or in painting a roof tile. A homeowner decided to avoid the process and go ahead and paint her roof a very deep shade of blue. And in an email to the board stated that they did not seek ACC approval because they knew they would be denied. My question is, if our documents state that homeowners must receive ACC approval for exterior changes, do we have a right to say that the roof must be reinstated?
I will say very close to absolutely yes. So long as the community has uniformly enforced the requirements through the years, and there's never been a situation where somebody made an alteration and without the board approval and the board let it go.
Okay. Well, thank you. We'll contact you.
Okay, well, we'll be happy to help.
Thank you.
Well, thanks so much for your call. I told you, you're quite a popular show for sure. The calls just keep coming in. We have about 6 more people lined up for you. Caller, what's your name and what's your question? Let's give them a second to connect there. Yeah, definitely a popular show. Your questions their questions are pretty good questions. I'm sure.
Well, there's so many things that come up.
Yeah, when you live in an HOA community, there's a lot of things that come up for sure. And I thought the first question was actually really good by John. So, caller, you're there? If so, why don't we go and just answer? I don't know if we can do a quick answer for Violet's question regarding a person with a prior criminal record, and then get to our call.
As I was saying, assuming that there is the authority to review and approve occupancy, either guests, lessees, or owners, the background check should be in sync with what your documents allow for. Typically, a criminal background check is undertaken, as well as something that involves the financial background of the individual. We have a caller. I hear someone else.
Yeah, I think we're getting connected. So just keep answering the question. We've got a little time, so
okay. Okay. The issue with criminal background is that the regulations adopted by HUD within the last couple of years have identified criminal background as an issue that could be problematic depending on the nature of the criminal background that's discovered. If the situation involves something of more of a felony conviction as opposed to a charge, and certainly less, not including a misdemeanor. We're looking at felony issues, which are the bigger crimes, and they have to be relatively recent in time to the application for occupancy, and they have to be of a nature that would be a problem within the community, such as one of more of a violence type, armed robbery type of situation. White collar crime might not be the same, although something involving things of a financial nature might be an issue. It's really, you have to look at it on a case by case basis, but because it's been linked to potential disparate effect on protected classifications due to the fact that many minorities are affected with criminal backgrounds they've determined, so they indicate that that's almost a gray area. So it shouldn't be your sole basis for disapproving somebody, assuming you have that ability to do so, but it certainly can be a factor. Before you disapprove anybody, it's strongly urged that you consult with the association attorney to make sure that you're not exposing the association to claims that might be very costly to try and defend.
It's a tough situation to be in, particularly if you have young children and there's, a pedophile in the neighborhood or a rapist. I mean, that can be.
Well, yeah, you certainly don't want anybody like that. Something of that nature is much easier to use as a basis. Somebody who was busted for possession of marijuana in 1999 might be a problem to try and keep out based on that.
Yeah, good, different way to differentiate it. I'm just going to check. Is there a caller on the line? It's a tough situation to be in, particularly
yes.
if you have young children and there's. What's your name, sir? A pedophile in the neighborhood or a rapist. I mean, that can be. Oh yeah. What's your name and what's your question?
Something of that nature is much easier to as a basis.
Oh, I heard a caller. Let's give him a second.
I'm also hearing the show.
Might be a problem.
Yeah, is your speaker turned down, Robert? I'm just double checking. Gotta have some background there. Let's go to our next question. Julie from Boynton Beach writes, what is considered a quorum?
Well, a quorum is going to depend on what your documents say. So for those who may not be familiar, a quorum is a necessary number of participants to have a legally convened meeting. Whether it's a member meeting or a board meeting, a quorum has to be present in order to conduct any business. For a board meeting, it's typically a majority of the board members. So if there are 5 seats on the board, then the quorum is 3, unless the documents contain something different. Bear in mind with board meetings, it's the number of seats, not necessarily the number of actual directors. For instance, you could have a 5-member board with 2 vacant seats, only 3 people are on the board, the quorum's still 3. So if only 2 show up, which is a majority of the actual number of directors, that would not qualify as a quorum and the business could not be transacted. With the membership meetings, in a condominium, it's typically going to be a majority of the owners to constitute a quorum, but you check your bylaws and your articles of incorporation to see what that is. In HOAs, the statute provides that unless your documents provide a lower number, the quorum is 30%. So you look to your documents to see if you have something lower, otherwise it's going to be 30%.
Okay, 30%. So why don't you give folks just a reminder about your classes? We're going to take a quick commercial and just remind folks where your website as well.
KBRlegal.com is where you can find us, and we have some classes coming up on July the 8th, 2020 legal update at 10 a.m. This is all going to be online, so you just go to our website to find it. On Thursday, July 9th at 1 o'clock is a condominium certification class, and on July Navigating Federal Fair Housing Act Assistance Animal or Pet. Those are upcoming webinar type classes.
Great. We're going to take We're going to take a short commercial break, and we're going to be back with Robert Kaye, who's going to educate us some more on community association law.
Don't let pests, rodents, and termites get the best of you. Call Command Pest Control today. When it's time to spray your lawn and keep those pests off your property, call Command Pest Control at 954-943-0008. Command Pest Control provides exceptional pest control in Broward and Palm Beach counties, so schedule a free inspection today. They specialize in all types of termite control, rodent control, and general pest control. Let their qualified staff protect your home and property from the damage and cost associated with common Florida pest infestation. Command Pest Control has been servicing the Broward and Palm Beach area for over 20 years with their qualified and licensed staff. Call them today at 954-943-0008. That's 954-943-0008 for peace of mind. At Command Pest Control, their goal is to offer you 100% customer satisfaction. For more information, please visit commandpestcontrol.com. Caregiver Services is the most trusted name in caregiving in South Florida. Caregiver Services offers skilled nursing, assistance with activities of daily living, shower or bath visits, meal preparation, housekeeping, companion homemakers, live-in care, special needs, and many other areas of home care. Caregiving Services also provides care for Alzheimer's and dementia patients, as well as transportation for doctor's visits. Caregiver Services conducts extensive background screenings, including Level 2 background checks. Caregiver Services accepts long-term care insurance and Medicare. Contact Caregiver Services today at 800-282-6409 or go to their website at csicaregiver.com. Trust the care of your loved one with the home care company that so many trust. That's Caregiver Services, where caring comes first. Call them now at 800-282-6409 for peace of mind.
Coming back. 4 callers. You're on.
The expert. Okay, we have 4 callers lined up for you, Robert. So, caller, what's your name? So, what's your question, caller, and what's your name? Surprise! You're on the air. Okay. Well, let's give a second. Let's go ahead and jump back into our questions. I think we're having a little bit of technical. Okay, we've got a caller coming in. Hello, caller. State your name and what's your question?
My name is Susan.
Hi, Susan.
Hi.
What's your question?
Can you hear me?
Yes.
Yes.
Okay. Okay, good.
Now we don't hear you.
Susan, go ahead with your question. Why don't we just jump into some of the questions from our listeners who've written in while they're connecting
Okay.
her. I think they're trying to work out some technical difficulties. So Frank from Fort Lauderdale writes, our community is governed by house and condo associations. The HOA has a member who has served a life member. Can we have dual officer for our HOA and condo association?
Well, it's kind of hard to figure out what the question exactly is right here, but I'm guessing we're having a situation where there's a condominium that has a master association that's a homeowner association that oversees certain common facilities to a couple different communities. And they have an individual serving on the board of both places. And the question is, can they do that? And the answer, of course, would be yes. I don't know about life membership. I don't think that's a real thing when it comes to community associations. It may seem like it when somebody keeps getting elected year after year, doesn't have anyone running against them. But there wouldn't be anything in the law that would preclude that. So as far as I could tell from the way the question is phrased, that would not pose a legal problem to have somebody that's serving on both the condominium board and the homeowner association board that governs the same property.
So no conflict of interest.
Not just for being on the board. If there's a conflict between the entities, that could be a problem, but that's not a common situation.
Okay. Our next question is Jack from Hollywood writes, we have HOA reserve funds. Can we use those for anything else they were meant for?
Well, with HOAs, reserves is a little tricky because they were added to the statute roughly 10 years ago. And when they were added, there was a requirement. Any HOA that was created after 2010 likely is not an issue, but for those that are older than that, the statute provided that to have what we call statutorily protected reserves, it's required that either they were provided for by the developer in the initial documentation of the community, or it would require a vote of the owners to establish them. Now, many homeowner associations that we've seen have line items in their budget that are called reserves, but they never had the vote of the members to qualify for the statutorily protected version. And they never were created by the developer. They were around long before that was a thing that developers did. So for those, their reserves are more of the type of contingency fund that can be used for any purpose, even though they may specify there for one thing. They could be reserving funds for road replacement, but if they're not the statutorily protected kind, they could use them for replacement of irrigation or other types of issues that the homeowner deals with. If they are the proper statutorily protected kind, then the same as with condominiums, they have to be used for the purpose that they're being held unless the owners vote to change them for something else. So there is a little different twist for reserves and HOAs, and the board would be aware of what kind theirs are before they start making changes to their use.
That's why having your representation can be very useful, right? About what you can and can't
Absolutely. Right, because
And
most people, lay people see reserve item in the budget, they think it's protected reserves, and it may not be.
how much trouble can you get in if you do break that contract and you use it for something that's not it's not delegated for?
Well, the issue for homeowner association, there is no overseeing administrative body like the Division of Condominiums that will come in and penalize the board or the association for improper use of the funds. That would require an owner to bring legal action against the association. It would be a breach of fiduciary duty by the board, and the damages would be the improper use of the funds, and then the legal fees that can be involved in the litigation can be into the tens of thousands, if not hundreds of thousands of dollars. So those are good things to avoid.
Yeah, it sounds like it. Fred from Boca writes, HOA problem with the swimming pool. Is the association allowed to make all new rules as to when the pools are open? Sounds like Fred wants to
That's
swim.
also going to be a document specific issue as to what authority the board has to make rules. Typically, if you have a homeowner association that has a community pool that falls under it, there will be a provision that says the board will have certain authority to operate the pool, which would inherently include establishing the hours of use. When the board does that, they have to do it in a reasonable fashion. They can't decide, well, we're only going to open the pool between the hours of 11 and 1 because people make too much noise. And so it would have to be more of a reasonable use and restriction as to how the owners are able to do it. Now, with the situation that we've been experiencing with the COVID issues, community pools had been ordered closed by the local counties, and then they were allowed to reopen under limited circumstances and without additional requirements. So depending on the county that you're in, you should make sure that your pool is in compliance with whatever executive order is in place in your county, and that may require some consultation with your attorney on that.
Right. So Cindy writes, we just found out our swimming pool needs new refurbishing. Do we have to have a board meeting?
Well, you still need to have a board meeting to take official action. Under Florida law, a board can take action either at a meeting or by a written resolution that's signed by 100% of the members of the board. Now, if you have an emergency situation that occurs prior to when the meeting date is, or you can't get together to have a meeting to address the situation, it may not be an emergency, may be urgent. Of course, the board can do that by communicating among the board members as to make sure everybody's on board, and then when you're able to meet, ratify the decision that was made prior. The board members shouldn't go off on their own and just make decisions without consultation among each other. While they're not allowed to vote electronically by email, they are allowed to discuss issues and possibly even reach decisions based upon the circumstances, so long as they're formalized at a subsequent time and ratified in the records.
So you can make some interim suggestions and then they'll go through a more formal process when they're able.
Quite often that happens almost regularly, and particularly in the summertime. Sometimes a majority of the board are snowbirds and they're not here, and getting them together for a meeting, even by phone or by Zoom, might take some doing, and those dealing with issues on site have to get things done. So quite often you have to make these decisions in between meetings and then ratify them.
Well, thank God we have Zoom. I mean, it's been a lifesaver for me in some situations. I'm sure other people are grateful for it as well during these times.
It is good. it offers a number of different benefits to community associations. Where it is problematic at this point is when it comes to membership meetings. Currently, the statutes don't really contemplate the mechanism to do that. Although many communities, has gone through the big meeting season in February, March, and April into May. That's usually when a large portion of the annual meetings take place. Some have postponed, but we're still in a position where having groups of people together is problematic. So doing it by Zoom certainly has its benefits, but based upon current statutes, it doesn't qualify. So there are legal entanglements that have to be revised or adjusted, but it's going to take an act of the Florida legislature, which won't happen until next year.
So we have to write new rules. So we have to write new rules for a virtual world.
Right.
Okay, let's continue.
Now, one of the things we found to be very well. One more point is that very helpful in board meetings, where it sometimes get out of control, if the person in charge of the meeting can make sure they only let the person speak who's speaking, so there isn't people talking over each other and interruptions and things that impede the ability to have a proper business meeting take place. So I think that's a good benefit to using Zoom meetings.
Yeah, it could be great. I mean, I've used it quite a bit for some classes I've taken, and it's worked great. I mean, sometimes you get kicked off. It's not a perfect tool, but it is allowing business to take place, which is great. We have a caller on the line. Caller, state your name and your question.
Hi, my name is Susan.
Hi, Susan.
Can you hear me? Hi,
we can hear you.
Yeah.
Okay, great. I just had a question. Our building, we're a small 17-unit building, and we were considering making the entire building non-smoking. Can you give me any insight to that?
Sure. You're talking about within the units as well as outside and in the common areas, correct?
Well, everybody has a patio. I'm thinking anywhere that's outside where the smoke can travel.
Well, outside is typically things that the documents will give the board the authority to do it through a board-made rule. It's best to put something like that in as an amendment to your declaration of condominium, because that's the stronger method and the more enforceable means relative to a restriction. And you can include within the units, if you're going to do the units, you should be amending your declaration to deal with that.
Would that take a vote of the association, or is that something the board can do?
Well, the board-made rule would be just the board, assuming your documents provide that. Some documents from the mid-70s do require owners to vote on rules. I suspect yours does not. But if you're amending your declaration, that will require a vote of the owners, and the declaration will identify the specific number of owners necessary to amend the declaration. So you need to look for that.
Right, we have a 3/4, right, I got you. And I don't...
Okay, well, 3/4 of 17 isn't... Go ahead.
Go ahead, I'm sorry.
I say 3/4 of 17 is doable, right?
Right, oh yeah, I mean, absolutely. So long as you had 3/4. So how would you diplomatically raise that? You know, we only have 1 or 2 units that smoke.
Well, I'm sure they won't be happy, but if you have an attorney that you use, they're generally good at phrasing things in a way that are a little bit more politically correct or neutral in the presentation, and hopefully somebody doesn't necessarily feel attacked or personally targeted. But sometimes that's unavoidable under the circumstances.
Right. I mean, if you've had an owner there for 15 years and now we're telling them that the building's no smoking.
They will not be happy.
Yeah. So it's a really no-win situation. Can you prevent someone from smoking out on their patio when it waves? Can you make it
It's
specific?
conceivable, but I would need to see your documents to tell you specifically. Chances are yes,
Gotcha.
but there is some potential issues that could be in your documents that we want to address first.
Right, whether or not they can smoke on their patio.
Now, if smoking on their patio is a nuisance to other units, that can be a problem that can be addressed either by the association or the affected units.
I gotcha. So have the affected unit deal with them directly.
And typically, if there's only one or two other units that are affected, it's an issue that's best between them and not involving the association, as the association's not the private police force for the individual unit or in a position to have to decide which one's right and which one's wrong. But where you have a clear violation of your documents or your rules, then the association is in a better position to take enforcement action.
I gotcha. Yeah, and the documents don't say anything specific to smoking.
No, they usually don't unless you amend them to provide that.
I gotcha. So we'd have to amend our documents, pretty much.
That would be the recommended approach, yes.
Right, and that would need the vote of whatever our documents state of the association.
Right. You suggested it might be 75%.
Yes, and that would take that to change the doc. Right. Okay. All right, then otherwise they have to deal with it amongst themselves.
Correct.
Okay. All right, thank you so much for your time. I appreciate it.
Well, thanks for listening.
Thanks for your call, Susan. We're going to take a short commercial break, but Robert, why don't you give folks a reminder about those great classes you offer?
Okay. You go to kbrlegal.com and look for the upcoming seminars. We have 3 that are coming up this month on July the 8th, 2020 legal update at 10 o'clock. Thursday, July the 9th at 1 p.m. is Condominium Association Board Member Certification Course. And on Thursday, July 23rd at 1 o'clock, 15, Navigating the Federal Fair Housing Act, Assistance Animal. These are all online courses. Some of them have continuing education credits. It's important to register for them and be aware. Also, I can tell you that there's going to be some webinars that Michael Bender and Jeff Rembaum will be providing in conjunction with some management companies in the area. They do some with Campbell Property Management. On July the 9th, they're doing one about mask requirements in Palm Beach County at noon. And then following it up for Broward at 12:30, that's July the 9th. And that should be something you can find on our website at kbrlegal.com. Or if you need us, call 800-974-0680.
We actually have another caller on the line, so let's take that caller right now. Caller, what's your name and what's your question?
My name is Barry from Miami. Can you hear me?
I can hear you, Barry.
Yeah.
Okay, my question is, it's a hard one, okay? I want to really test Mr. Kaye. We have a document.
We lost him.
It will automatically incorporate future statutory amendments. And what we want to do is adopt the Kaufman language, but carve out certain exceptions because we feel some provisions would not be beneficial to us. And I'd like your thoughts on that.
Hey, Barry, part of your question blanked out, so I'm not sure I heard it all. You say you're thinking about putting Kaufman language in your documents, or you already have it?
Yeah, we do not have Kaufman language. We want to include Kaufman language, but two areas that we feel would not be beneficial. One we discussed last month. We're concerned about short-term rentals. We want to lengthen the minimum rental from 1 month to 6 months. We feel, based on, I think you said last month, if we don't have Kaufman language, that provision won't, the law that was enacted in 2004 would not apply to us. And the other area is the 8-year term limit. We want to make sure that that limit does not apply to us. And I think we can rely on a DBPR decision if we do have Kaufman language that limit would not apply to us. So we only want to pick up the favorable provisions, but not pick up anything that we deem unfavorable.
Well, first off, the 8-year term limitation is likely not a statutory amendment that's subject to the Kaufman issue. It's considered more procedural, much like condominium elections that apply across the board, regardless of what your documents say. So I'm not aware of a mechanism at the current time to include in your documents to eliminate the requirement of the term limits that were put in place in 2018 that don't happen until 2026, and a lot could happen between now and then. Other specific issues on the leasing portion, if your documents are more strict in their limitations than what the statute provides, even with the Kaufman language, the language of your documents is going to prevail over what the statute says in that instance. So if the statute is amended to allow for short-term rentals, but your documents do not and clearly cover the issue, then your documents will be the controlling aspect on that issue.
Okay, I guess I didn't understand the 8-year term limit. I thought there's a decision, the Glantz decision, that where they did not have Kaufman language, and the DBPR held that because there wasn't Kaufman language, the 8-year term limit did not apply. So that's what we want to rely on.
No, the 8-year time limit was not one that was retroactive in its application. So it only began in 2018, starting in July 1. So anyone who was elected prior to July 1, 2018, their time of service doesn't count. Kind of similar to what they just did in Russia to allow the president there to add 2 terms to his time of available service by changing the Constitution. They did that with Florida statutes as it comes to members on the board for condominiums. And so it erases your prior time, and the clock starts to run on July 1, 2018 for your 8 years.
Okay, thank you very much. I appreciate it.
Okay, Barry, thanks for listening.
These are really great questions. So I'm learning
Always.
a lot here, some that I'd never even thought of, and I'm going to be buying, I'm sure, probably in an HOA community at some point. I'm renting in one now. It's very low key. So it's actually very helpful to hear some of the questions that people are asking.
Rhonda, keep listening when you're not hosting.
Yeah, exactly. We do have some callers on the line. Let's see if we're going to give them a couple of secs to connect. Let's see, state your name and your question.
Hello?
Hi.
Hello.
What's your name?
Hi. My name is Karen. I have a quick question about service animals.
Go ahead, Karen.
Okay. We have a couple people that have service animals. Is there any statute that says that we can ask for updated letter from the doctor and from the veterinarian and for their the dog shots and et cetera? Is there any kind of statute that we can legally ask for that?
Well, the statutes are not as specific when it comes to what you've described. generally speaking, if somebody makes application for what's called a reasonable accommodation to allow for an emotional support animal or a service animal, and their need is not obvious, such as a blind person with a seeing eye dog, that's an obvious situation. But emotional support animals are not something that you could tell just by looking at somebody that they need that. Then they're required to provide certain documentation from a qualified medical provider, and that it has to meet the specific levels that the Fair Housing Act has set forth on major life function impairment, and that their animal will alleviate these issues so they can have full enjoyment of the property. Now, there isn't anything that identifies an entitlement in the association to ask for a periodic update as to the need relative to whatever condition they have. So we don't recommend you do that. But for the animals, medical records and inoculations, and make sure that they're keeping up on that, that would be part of what the association should include in rules that they adopt relative to the keeping of emotional support animals within the community. And we do provide that to our clients when they get involved in these situations. You should have, in addition to a package of application materials that include identifications of the medical provider and forms that they can fill out to provide to you, rules for what they can do and can't do within the community. More what they can do, because they can go wherever the owner can go with some minor limitation, like they can't go in the pool, although they should be able to go on the pool deck. The exercise room, if you have one, that might be a problematic area, but generally speaking, there's very few places you can keep them from. But they are required to clean up after their animals. They are required to make sure the animal's not a nuisance, doesn't cause problems with barking or is physically aggressive, and requirement of maintaining their medical records up to date is one that certainly can be in there.
So it can be put in as a rule from the board of directors.
Yes.
Okay. And can that be asked of can that rule be put in for the owner as well, the pet owner, as well as the dog or cat or horse or whatever they have?
Well, you wouldn't be able to ask the human for medical updates unless their situation is such that it's temporary and obviously temporary at the beginning.
Oh, gotcha. Okay, so that can't be updated, but we can ask for updated records as far as a service animal permit and the proper shots from the vet.
Well, there wouldn't be a permit requirement for emotional support animals, and under the fair housing laws, certification is only for ADA, which is in public areas.
I apologize for cutting you off here, guys, but we're running out of time, and this wraps it up.
She's still going.
For Ask the Expert. So if you have more questions, please call in next month. We appreciate your call. I'm sorry I have to go, but we're running short of time. That wraps it up for Ask the Expert. And we're going to be back at the first Thursday of every month with Robert Kaye, our expert in community association law. Thank you so much, Robert.
And thank you, Rhonda. Good to see you.
Good to see you as well.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.